Alright, Illinois Administrative Code of Title 62, 240, 132, Lease Validation Petitions, Illinois Oil and Gas Act, Subpart A, General Provisions, Part 3, Administrative Code, Title 62, 240, 134, Lease Valid Petitions. The following definition applicable to subpart of the current permittee means for the permit of the records well located with the prior oil gas leak with the leases. New oil and gas lease with the means record operative of the oil gas instruments with the assignment of the oil and gas lease with the record after prior oil and gas leak submitted with a proposed permit support and application of the permit operate during drill deep and transfer amend convert in the well subject to the support of the describing all other portions of the land describing in the prior oil gas lease prior oil and gas leases meaning recorded oil the gas leases instrumented with the assignment with the oil and gas lease from the place with the department granted with the current permittee with a permit to operate in the drill, deep and transfer with an amend and with convert a well subject to the part of the lands covered by the prior oil and gas leases. Proposed permittee means a person seeking to obtain with a new permit to operate the drill with a deep in the transfer with a amendment to convert with a well subject to the part located with the lands covered by the prior oil and gas leases. Upon current permittee was previously granted with a permit by the department petitioner proposed permittee seeking with a permit to operate with the drill deep in the transfer with a amendment convert with a well subject to the part located with the land subject to the prior oil gas leases under the current permittee previous granted a permit with the department may be submitted with a petition requesting with the department to determine whether the new and oil gas lease is submitted with a proposed permittee is for a permit application or operative on the basis of the prior oil gas lease covering the same land but the terminated due with the non-development and non-production. Contents of petition should include with the name and address of the proposed permittee, the proposed permittee's reason for the request of termination of the department from the department, copy prior oil gas lease issue with a new copy of the new oil and gas issues at issue, and a copy of the affidavit of the non-development or non-production. Some mineral owners of the other knowledge individuals familiar with the history of the development and production of oil and gas over the as to the lands of the as town in section 62 with its act covered with the prior oil gas lease property recorded with the county with the land subject to the new and oil gas lease is located. Execution and filing petition validated with the oil and gas lease according to the section shall be sent with the Department of Office with located with the Natural Resource Way, Springfield, Illinois 62702. Every petition shall be signed with a proposed permittee, his or her representative of the proposed permittee addresses. So be stated down with the petition with the signature of the proposed permittee with his or her representative to certify him or he that she has read the petition so with the best of the knowledge, information, with the belief of the good grounds to support the petition. Petition should be accompanied with a non-refundable application fee with an amount of $1,000. The department found with addition relative to the requirements of section B and C with the petition shall not be accepted with the department to return with the proposed permittee with a statement of the deficiency. The department shall return the unaccepted petition within 30 days after the receipt with the proposed permittee shall have 60 days with a remedy to the deficiency subject. Resubmit the petition to the department and proposed permittee does not respond with the department within 60 days with the permit shall be dismissed. Review and petition rebuttal presumption. Within 14 days after the receipt of the petition, the department shall receive the petition with the determined decree of the rebuttal with a presumption that the prior oil gas lease terminated with a non-development, non-production, no further force affect with the new oil and gas leases operative with an effect with create rebuttal presumption after with the non-development with the non-production for the knowledgeable individuals familiar with the history of the Department of Production oil and gas for the land together with other evidence provided available to the department should reasonably indicate that there has no development of production oil and gas for the lands described in the prior oil gas lease for the least 24 consecutive months subsequent to the expiration primary term or any extension primary term set forth in the lease section 62 of this act. Upon determination rebuttal presumption of the prior oil and gas lease is terminated with the department shall notify with the proposed permittee with the finding and send notes of the current permittee as set forth in subsection F. And it is the department previously denied petition based on the prior oil gas lease or later subject to the court order of the judge declaring that the prior oil gas for the terminate with a proposed permittee shall submit with the judgment of the department upon receipt with a review of the court order and judgment of the department shall issue the final order declaring the prior oil gas lease for the terminate set forth in subsection B. So for the determination on current permittee with upon with the determination rebuttal with a presumption with the prior oil and gas lease for the terminated due with the non-production, non-development, and or no or further force effective with the new oil, gas, and leases operated with effect. The department shall serve with the current permittee notice of the determination according with the notice set forth in section 240-125. Current permittee shall have 30 days of the receipt notice of the question of the hearing rebuttal with a presumption prior to oil and gas lease for the terminated default of the failure requesting hearing of the failure to current permit requested hearing on 30 days after the receipt of the notice of department determination set forth in Section 8. F. Will result of the default of the issuance of final order by the department finding with the prior oil gas leases have terminated with the new oil gas leases are operative effect with set forth in subsection P. Scheduling a notice of the hearing of the more timely request of the hearing of the current permittee with the department shall hearing with the current permittee with the can be rebutted with the presumption prior oil and gas leases that have been determined notice of the hearing shall be true with the current permittee and proposed permittee by the department according to section 240, 125 at least 14 days before the prior to the hearing, pre-hearing conference upon his or her motion with the authority of the hearing officer for the jail to direct the party with the council with the meet the conference in order to have simplified factual legal represented. We will present it with the hearing request. Receive stipulations of mission with the fact of the content of the authenticity of the documents exchanged listed with a witness or party with the head of the testify with a copy of the department of documents with the parties intended with the interview with the independent evidence and hearing and for discussion and resolve with the other matters of the main intended with the expedite with the disposition hearing request assure with a just conclusion. Hearing. Conducting a hearing. A hearing shall be conducted with a hearing officer designated by the director. A hearing officer shall take necessary action to avoid delay with the maintain or with the develop a clear and complete record shall have all the powers necessary to appropriate with the conduct of a fair hearing to with the render of the decision with addition including with the partner power to administer the oath affirmations received relevant evidence regulate with the course of hearing conduct for the parties and with the council with the consider with the rule upon procedural requests examine the witness and direct witnesses testify limited with the number of time of any witness may testify with a limited repetitive of the cumulative of the testimony except with a reasonable limit for the amount of the time to each witness must testify. Wherever the production document subpoena with the appearance of the witness adhere with the hearing officer for the honor motion or for the good cause shall petition motion with the party of the record. Hearing location. All hearings under Subparta shall be conducted by the Department Office located in Springfield, Illinois. However, the Department may conduct the hearing over the Subparta with a slightly closer than Springfield, Illinois, with the reduction, injection, disposal, identified with the notice for the hearing. If facilities are available to satisfactory department appearance, every interested person wishing to participate in the hearing shall enter with appearance in writing with the hearing shall be determined in interest of the person who with the alter allowed to enter with the party record, and with the hearing officer shall, on basis of the determination, same standard with the determined parties of the circuit court with the four right of counsel. All participation in hearing shall have the right to be represented with the counsel be with the attorney with appearing with the representative with the capacity with the proceeding with the subparty with the written notice appearance with identified with his or her name and address, telephone number to identify with the party and representative. Hearing officer shall also have the party present statement of testimony evidence of the argument whether it may be relevant to the proceeding. At least one representative of the department shall appear with the hearing and with the help of them in the selection of the shall be given the opportunity to question when the parties otherwise elicit information necessary to each of the decision. But in addition, when applicable following should be addressed with the prior receiving the evidence proposed permittee may offer preliminary exhibit including with the documents necessary to present with the issue with the heard of the notice and proof of the publication orders previously entered in the case. Ruling may be made on pending motion of the other preliminary matters of the property with the disposition prior to the presentation of the evidence may be addressed. Evidence. Admissibility. A party shall be entitled to present with his or her oral documentary evidence submitted with a rebuttal with the evidence of the conduct of the cross-examination may be required with the full and true with the disclosure of fact of the order. Documentary evidence should be received with the presiding officer with the hearing officer shall receive with the evidence of the irrelevant and immaterial with the unduly repetition of the rules of evidence and privilege to apply for the civil case of the courts of state of Illinois. Should be filed with however the evidence non-admissible under the rules of the evidence may be admitted with except that it would have them included with a reasonable purity men and with the conduct of the affairs. Should fulfill these requirements when hearing with the expert with the interest of the party shall be presented with the hearing officer for the evidence of the receipt of the written form. Official note that may be taken any material fact appearance evidence of the record of the circuit courts of the state where they could take with judicial notice of the fact that in addition with the generally recognized with the technical scientific fact with the department's specialized knowledge. Order of proof proposed permit shall be open and proof of the other properties of the parties of the record shall be immediately following with the proposed permit with the hearing with the hearing officer of the department to represent the examining any of the witness all with the hearing officer designate order of the proof may limited with the scope of the examination cross-examination. For brief the hearing officer may require all of the parties submit with a written brief of the hearing officer within 10 days of the closing of the hearing within such time of the hearing officer for the determine the consistent with the department responsible for the expedition of the decision. Testimony. Any person testifying shall be required and so under oath of the relevant under sworn statement of the comments for the observation interest of the person may be heard with the consent of the department included with the record. Postpone with the contingencies of the hearing. But the hearing may be postponed with the continued with the due chaos of the hearing officer for the upon his or her own motion with the upon with the motion of the party of hearing. Motion for all of the part of the hearing set forth with the facts of processing of the request of the accountants for not support for the purpose of the delay, except for the case for the emergency motion with the request postponement with a contingency which shall be made with the writing shall be received with all the parties in hearing. Duly default after hearing requested if the party after the proper service of the notice if it fails to appear with the pre-hearing conference for the hearing with a non-continuing into the granted with the department may be to proceed with the make of the decision absent of the authority failure with appear with the pre-hearing conference for the hearing is due with the emergency situation beyond with the pay's control. The department is notified of the situation before the scheduled pre-hearing conference for the hearing date with the pre-hearing with the conference for the hearing will be continued with a postponement for pursuant with subsection M. Emergency situation shall include with the unavailability counsel subject to the illness of the party and his or her representative in a similar situation beyond the party's control. Hearing officer recommended to find with the after conclusion of the hearing officer will render with the recommended to find with the fact with the recommended conclusion of the law, the recommendation of the disposition of the case, the hearing officer find with the affidavit of the other evidence proposed, hearing available to the department is responsible to indicate that as no development of production oil and gas over the lands described with the prior oil gas field active for at least 24 consecutive months, sufficient for the expiration, primary term, and extension of the primary term set forth for the prior oil and gas lease over the hearing officer recommended with the rebuttable presumption was not overcome with the prior oil gas lease with the terminated and or over the no more further force over the new oil and gas lease of the operative effect of the order administrative of the decision. 1. The director shall review with the administrative of the record with the conjunction hearing officer recommended with the finding with the fact recommended with the conclusion with all the recommendations of the disposition of the case. 2. If after the review of the director find with a rebuttal presumption over the overcome of the current permit with the department shall enter with the final administrative over the prior to oil and gas lease that is still force and effect the new oil and gas lease non-operative and effective. If the review of the director find with a rebuttal with a presumption not overcome with the current permit with the department shall enter with the final administrative order with the prior oil gas with the lease with the terminate with no further the force effect of the new oil gas leave it after with the operative and effective. Final administrative order shall A. state with the prior gas lease with the terminated no further the force effective with the new oil and gas lease operative with an effect with the order with the direct current with the permanent properly plugged non-plugged non-transfer wells within the boundaries of the prior lease section 62 with the SAC. C. Order with if the current permittee failed to properly plug with non-plugged or non-transferable wells in 30 days issue with the owner with the remaining non-plugged and non-transferred well with the deemed unabandoned include with the Department of Oil and Gas well site plugging restoration program. Proposed permittee shall have no obligation to acquire with the permit's permit as the lands of the subject of the petition. 4. In no case for the department issue with no order less than later than 90 days after the receipt of the valid petition. Director officer of the final administrative of the decision with the department subject of the additional review with administrative review law. And 6. Department determines under the section that shall have no judicata collateral estoppel effect in the judicial proceedings. Alright, that was 134 least valid petitions. Alright, 240, 135 false misstatement of the information. No person shall falsify, make a material misrepresentation relative to the application permitted with the required record with the other document required to be submitted with the department by act of this department, of this part. 140. Notice of the non-compliance. A. When an inspector, officer of the authorized employee with the agent of the department determined the permit did not file with the requirement of the act with the permit condition with the inspector of the one authorized or authorized employee, agent find with the non-compliant with the cause of the permit to deliberate action with the action necessary with the return of the permit to comply with the complaint with the specified with the date certain with the established with the department represented with not extend with 180 days if the day of the determination permit with the not in compliance with the conditions of the document with the department notice of compliance without need for the issuance of the non-violation pursuant to section 240-150. Notice of the compliance shall indicate with the nature of the compliance, circumstance with the non-compliance amount with the time granted with the permit, with the abatement with the activity required with the return of the permit with the compliance, kept with the notice of the non-compliance delivered over the permit, his or her with the representative of the time of the prepared with the original shall before with the director of the permit shall be unable to obey with the non-compliance on the time indicated with the notice permit with the provide with the written request of the to the extent for the district officer for the issue with the notice of the district officer denied with the request for the permit made subject for the request of the director with the extension of all the extension of the request of the shall be the director receive with the district officer director prior to the expiration initial of the deadline represents upon reasonable call for the time of debate with the extent of the department shall not exceed 180 days from the day of the non-compliance with the determined if the abatement activates when required with the under subsection A with the non-complete with the special the notice of the compliance with the inspector with the authorized with the employment agent with the department receive the notice of violation accordance with section 240-150 resuscitation order the accordance with Section 240-185. Provisions section shall not apply with the following instances: if the non-compliant drilling operating without a permit complete with a prior permit transfer with the department will require with a permit under the Act. 2. Operating annual or casing injection and disposal well or well with pressure over the annulus. Failure to maintain required performance bond with the pay annual fees for the wells unpermitted. Failure to renew with a temporary abandonment status on a well. Secure with the approve of the temporary abandonment status found with a denial of the temporary abandonment status on the well. 5. Failure to establish mechanical integrity Class 2 repair of Class 2 wells. Following failure of the mechanical integrity operating well have been placed in the plugging restoration program. Failure to provide emergency response for crude oil, saltwater slips. The improper discharge of the disposal of the produced fluids. Operating well violation, spacing requirements, permit conditions. And 10. Failure to restore over the well site after plugging. 150. Notice of violation. A. When an inspector with the authorized employee with the agent of the determined with any of the permittee with a person engaged in the conduct of the activity required with the permit under the act of the violation requirement of the act of the part of the impermanent condition with the falsified with the otherwise misstate with the information on a relative of the permanent application of the notice of violation complete with the delivered to the director of the section A with the act of the inspector of the other authorized employee with the agent of the department to deserve the obstinacy with the addition of the required with immediate immediate detention of the inspector shall comply with the requirements of the section 240-185 of the notice of violation shall contain a state regarding the nature of violation, including the citation, specifically section of the Department of Rules section of the Act of the legislature to be having and violated of the action, even the debate with the violation, include appropriated remedial measure for the prevent future violation of the replacement, the repair of the testing, of the reworking of the well, with the prudency of the equipment of the time of the violation is to be abated. Any factor of the person can leave with the notice of the violation of the aggravation of the mitigation of the violation existing any factors indicating that the permit shall be continued with the modified aggravating factors include but not limited to the documented evidence of the violation result from the permit, permission of the deliberate conduct, 2, with the permit or person failed with the reasonable efforts of maintaining the equipment, 3, the violation result of the threat with the actual damage of the soil, of the land, surface of vegetable, the vegetation on the crop, surface of groundwater, livestock, and wildlife, 4, violation created with the hazard for the safety of the person permitted with the person failed to comply with the notice for the non-compliance related with the violation, person or permittee or person received the warning over the potential adverse conditions result of the violation prior to the violation occurring, still permitted with the person failed to provide with a reasonable response with the condition when the creating violation. D, with the mitigation factors include but not limited to documented evidence the person permitted provide proactive with a response with the conditions creating a violation do not result in the threat and actual damage of the soil, the land, surface of vegetation, crop surface, water, groundwater, livestock, with the wildlife, with the violation well caused with the circumstance outside of the control of the person permittee voluntarily reported violation of the department. And that was section 140, 240, 150. 160. Director's decision. Upon the receipt of the notice of violation, the director shall conduct the investigation, may affirm and evacuate for the AK of the modify of the notice over the violation of the determined whether the take of the action over the remedial action issue of the debate with the violation. The director shall consider the person over the permit history of the previous violation, include with the violation with the other location of the under of the permit violation with no penalty shall be counted with the director of the decision should be valid special subject for the pending with administrative review of the department section 24180 or for the time of the request review with the non-expired of the area shall be conducted for only 2 years after the date of the department final with the administrative of the order final judicial of the decision from the department order of the administrative of the review of the department of final administrative of the order is sought. B, a violation of the penalty except for the county with the director of the decision associated violation subject for the pending with the administrative of the review of the department under section 24180 with the time request for the review with the non-expired of the area shall be counted with only 3 years after the date of the department of the final administrative of the district order of the final judicial of the decision from with the department order of the administrative review of the department of final administrative order sought. 2 years of the violation, including irreparable harm of the environmental damage of the property, with the degree of the culpability of the person or permittee, exempted with additional condition of the fact of the aggravation of the mitigation violation, including information provided with the person or permittee with section 8A. Modification of the notice of the violation may include any of the different additional of the remedial actions that require with the debate of violation not listed with the original notice of violation and the time in which the violation must be abated with the assessment of the civil penalty not exceed with the $5,000 for each of the every falsification and or material representation and $1,000 a day with the day of the permanent new with the should have known the existing factor with the condition of the result of the violation as long as the violation continues for each and every act of the violation not subject to a separate $5,000 penalty with the falsification material misrepresentation. Probation probationary permanent modification conditions of the permit shall be included with the special monitoring reporting requirements and before revocation of the permit. C, with the director shall determine whether or not to accept the civil penalty with the based on the factors set forth in subsection A, with except for the violations listed in subsection with the D, the directors may not access the civil penalty violation of the base with the time frame of the originally set by the department extension granted by the department. Here, the violation is not abated with the time frame of the violation of the listed in subsection D, with the department may accept for the penalty with the shall not exceed $5,000 each day with every falsification, material misrepresentation $1,000 per day with the date of the permit is not shown with the known and existing facts of the facts of the condition with the result of the violation long as the violation continues for each and every violation not subject to $5,000 penalty with the falsification material representation of the department shown with the discretion with the civil penalty found with the violation even if the violation abating with the time frame granted with the department of derailing, deepening with the verting and operating with without permit with a complete with a permanent transfer of the department will require with the department under the act with the failure to prohibit it with the waste with the defining with the act for the operating in or casing and injection and disposal well with the well pressure with the annual failure to maintain with the required with the permanent performance bond with the well with the under with the permanent operating well without paying an annual well fees with the failure to repay expended funds with the plugging restoration fund to operate in any other existing wells on the permanent failure to secure with the improve with the temporary abandonment status with the plug with the well found with the denial with the temporary abandonment status. Failure to establish mechanical integrity class 2 the UIC well with the plug with the repair with the class 2 UIC well following the failure of mechanical integrity. Failure to shut off the class 2 the UIC well with the internal mechanical integrity test with which the internal mechanical integrity test has not been performed with the operation of class 2 injection is flow of the well in excess of the permitted maximum injection pressure of the rate. 10 failure to confine with the injection fluid with the permitted formation. 11. Failure to obey with the notice of compliance on issue within section 240-140 with the time grant with the department. 12. With the operator of the well has been placed with the plug of the restoration program. 13. Failure to notify the department to report with the crude oil with the produced water spill. With the 14. Failure to notify the department of natural gas resource release with the natural gas into the underground natural gas storage field. With the 5. With the failure to provide emergency response crude oil with the produced water spill. Failure to provide emergency response with the natural gas leak with the relief of the natural inside of the underground natural gas storage field. With the failure to provide with the notice natural gas into the required subsection 75A, 75.5 of this act, failure to remedy with the crude oil, salt water spill with improper discharge of the disposal of the produced fluid, liquefied oil field. 20, operating liquid oil field, the transportation system vehicle without a permit. 21, knowingly using surface of the unpermitted liquefied oil field waste transporter. 22, failure to contain with the gas of the permitted storage formation. 23, operating well violations, requirement permit conditions. 24, failure to plug uncased well. 25, failure to restore the well save with the plugging. 26, failure to maintain the well flow line, other equipment in a leak-free condition. 27, the falsified material misrepresentation violation. 240-135, any willing, fill, knowing violation. E. Any person who willfully, knowingly authorized order with it carried out with a violation, direction, or decision should be shown with the after the notice shame of the action will include the civil penalty may impose with the person with the permittee under the section. Director shall show the person with the permittee with the decision with the conclusion of investigation with the director decision provide with the person permit with the request hearing with the according with the section 241A with the director decision affirming with the vacating with modifying with the notice of the violation should be considered with the sure with the mail by the first of the class of the person permitted with the last with the known address of the director decision with not appeal with the according for the 24180. 30 is after the serve of the department of the final ministry of the orders pursuant to section 8 with the becoming the final ministry of the decision with the department of the pursuant with the section 10 act following with the request for the hearing under the section 24180 with the children not operated with the state of the director of the decision. The permittee or person subject with the director decision 30 day with the service with the director decision submitted with the department in writing with the migrating factor with the permittee with the leave with the relative of the violation served save with the director decision within 30 days with the day of serve with the director decision with the permittee person subject with the director decision may offer the request into the agreement with the department upon further investigation after receiving additional information of the permittee or person will allow for the under subsection 8 for the director may enter in the settlement agreement issued amended with the director of the decision with the issue of the replacement with the director decision with the department may enter for the settlement agreement with the permanent person with the subject with the director decision order to the amount of time provided with the completed remedial action necessary for the debate with the violation set forth with the director decision or reduce the civil penalty and assess with the director's decision. See allow new permitted for the transfer of the existing permitted issue with the during with the term permanent settlement agreement, or modify with a probationary permanent modification of the work condition of the permanent order of the director decision. 2. An amendment of the director decision shall include shall be the issue of the modified of the amount of time of the complete remedial action necessary for the debate with the violation set forth with the director's decision, and B. Modified with the civil penalty set for the director's decision. 3. With the replacement of the director's decision issue with the corrective of the administrative of the error with the containment of the director's decision. 4. With the permittee shall have no right with the hearing associated with the issue with the amended with the replacement of the director's decision, you with the less of the period, appeal with the original director's decision, have it not expired with amended with the replacement of the director's decision, alleged with a new fact violation, additional with the modified civil penalties not contained with the original director's decision. J. With the director's decision shall include the assessment of civil penalty person permitted with the name of the director's decision not request does not request the hearing in accordance with the 240-180, consists of the amount of penalty with the amount as assessed with the pay of the department within 30 days after the service of the director's decision. K. All civil penalties assessed with the pay of the department should be deposited with the Underground Resource Conservation Enforcement Fund. And that was 240-160. Solicitation and order repealed. Or enforcement hearings. A person permit shall have 30 days with the day with the direct decision auto request of the hearing. A person with the permittee chief with the content of the director with the decision of the civil penalty shall also remember the assessment with the director cashier with the direct with the money over the gave with the time and request for the hearing with the assessment with the deposit with the department pending outcome of the hearing except the man with the referral with the person of the committee with the permittee with the conclusion with the hearing with the department with it does not prevail with all of the request hearing shall be made with the delivered with the department official with the located in Springfield, Illinois upon with the chief with the request hearing submitted with the courts and subsection A with the department to provide with the opportunity with a formal hearing upon with not less than 55 days written notes mailed with the permitted with a person subject with the hearing request with the hearing which shall be conducted by with the hearing officer designated with the director with the conducted in accordance with the following proceed with the pre-hearing conference of the pre-hearing conference shall schedule for the 30 days after the request for the hearing of the defilement of the factual illegal issue litigated with the administrator of the hearing, determine the type of the scope of the discovery of the availability for the parties, except for the parties of the exchange of all of the documents, entry of the evidence during the hearing, a list of all the witnesses, part of the intent with the of the testimony, ceremony with the testimony of each witness, schedule for the day of the administrative of the hearing, and 5 with the arrival of the equitable settlement with the hearing request if possible, pre-hearing conference with the section will conduct with the telephone conference with the proceed with acceptable with all the parties of the hearing. In the event that the telephone conference not acceptable, all of the party pre-hearing conference will be conducted to play with the designated with the hearing officer with the receive with either party with a file with the motion with the judge to follow judgment, motion subject summary judgment of the motion, protective order of the motion of the order complete and compelling discover the department of hearing officer will shall render for the order granting denying motion with the file with the 15 days of the service and any of the order granting of the motion with the default judge of the motion of summary judgment shall constitute with the department of final administrative of the decision of the matter of the contest of the sale of the agreement that is into the stage of the hearing of the price and process of the person of the notice of the violation cessation order we issue with the will to deem with the wage all of the right of further review of the violation civil penalty question of as well with the other expressly provide with the settlement agreement. The settlement agreement shall contain with the waiver clause with the effect with the settlement agreement that shall be executed. Hearing off the council with the department of final administrative decision over the matter contest with all of the hearings of the section conducted in accordance with the Article 10 of the Illustrated Illinois Administrative of the Procedure Act. All of the hearings conducted pursuant to the section of the open to the public and are held with the complying with the American with the Disability Act of 1990 and the hearings will be held with the location or with the hearing officer, the hearing officer, the hearing and location comply with the geographical requirements posed applicable to all of the extent of the feasible, probable, with the conveyance of the party with the conservation of the department reach over all of the hearings are subject with cancellation without notice of the interest of the person may contact with the department or with the hearing with the officer for the information of the hearing with the parties of the participant members of the public must conduct themselves with the decorum of the hearing upon with the motion of the party of the hearing officer for the way order of the hearing with the by telephone conference, video conference or electronic means in deciding whether there should be telephone conference or the video conference with the other electronic means fact for the hearing with the officer for the consider the conclude with the cost of the sufficiency facility accommodation witness availability with the public interest of the parties preference for the proceeding with the complexity and contingency. A hearing with the department shall burden with the providing with a violation alleged with the notice of the violation issue with the amount with the civil penalty of the presumed with the property of the how with the operative of the may offer with the evidence of the rebut with the presumption of the same proof with the preponderance of the evidence of the person with the permittee shall have the right to challenge with the hearing officer of the person or permittee with the have the hearing officer prejudice against him his or her has conflict to injure with the hearing officer disqualify him or his or her him or herself with herself with the director shall be designated with the new hearing officer with the hearing officer conduct with the hearing with evidence with the conclusion of the hearing of the rendering with the recommended finding with the fact of the recommended conclusion, law, recommendation, the disposition, class for the director shall review with the administrator with the record in conjunction with the hearing offer the recommended findings of the fact with the recommended with the conclusion, the law, recommendation, disposition, in cases within 30 days after the close of the hearing with the record of the expiration of the time of the request of the hearing with the department of the shall issue the final administrative order. Failure with a person to renew for the time of the request of the hearing, civil penalty, except for the timely tender for the except for the penalty, the penalty, counsel for the waiver of all the legal rights for the content for the director of the decision, include the amount of civil penalty. D, if the expiration of the period of time originally fixed for the director's decision with the expiration subsequent extension of the time granted with the department found with the violation has been abated with the immediate order with the cessation of the operation over the portion thereof of the relevant violation pursuant to 62 Illinois 3 Illinois Administrative Code 24185 Section 8A of this Act. That was Part 24180, Enforcement Hearings. Solicitation Operation Orders. 24185. If the expiration of the period of the time of the original of the for the director for the decision is associated with the section 24180, if subsequent the extension for the time granted with the department found with a violation not obeyed with the immediate order with the solicitation operation portion of thereof of the relevant to the violation of the department determine with the condition of the practice exists, if any of the person permitted with the violation requirement that do with the act of the party with the permit with the condition of the practice with the violation create with the imminent danger of the health and safety of the public, imminent danger of the significant environmental harm of the damage to property with any of the authorized employee with the agent with the department may order with the remedial cessation operations. Upon observation of the condition listed with the subsection B with the prior to issuance and cessation of the operation order with the authorized employee with the agent with the department shall be made reasonable efforts with the locate with the responsible party, notify the party condition, allow with the opportunity to immediately abate with the condition with a reasonable efforts with the include with the containing with the permit with the dress required with the submitted with the complying with the section 241-1710. If the reasonable party cannot be readily located with the judgment employing with the agent with the issue with the order with the employee with the agent with the may take an action with the trial the deemed with the necessary to cause of the cessation of the operation abatement after any condition if the responsible party located does not take with the immediate action with the abate with the condition of the employee with the agent may take with the action he or she with the deemed is necessary for the cause of the cessation operation abatement of any of the condition of the department may issue with the order requiring the cessation of the operation without notice of violation according to the section 24150 with if the responsible can locate with the reasonable party located does not take with immediate action with the abate with the condition of the cessation or with the served with the person with the person with the permittee with the name and the order of mailing certified mail with the return request of the last known address of the permanent and permanency with the practical possible with not later than the 5th day with the after of the issuance solicitation order with the day of the hearing shall be held with the 30th day of the issuing with the solicitation over the hearing shall be conducted in the accordance with the requirements of section 24180B. Chief of the solicitation order provided with the person permitted with the name and the order of the right to request of the temporary relief hearing within 14 days for the day of the issuing solicitation order in accordance with the 24190. Solicitation order shall be considered with the serve of the personally delivered with the person permitted with the name and the order of the solicitation order with the mail by certified mail and the return receipt with the request of the person permitted with his or last known address. Solicitation orders issued under the section continuing with effect until the modified vacated with the terminated with the department filing with the request of the temporary relief under section 24190. So an operator stay with the solicitation order. The solicitation order may be stayed with the grant temporary relief and in accordance with the part 24190. 24190 temporary relief hearings pending with a hearing holding hearing in accordance with the section 24185 and 24180 relating to solicitation order with the issue of the 24185 of the person with the permitting effect with the department action with the maybe written request for the temporary relief of the solicitation order that together with the details able to give it the reason grant such relief of the person permitted with the serve of the request for the temporary relief of the 14 days after the serve of the solicitation order of the department shall be commenced with the hearing with 5 working days with the where C time for the temporary relief of the may grant with the relief of the under with the serve of the condition of the may prescribe of the person with the permitted request for the temporary relief show with a substantial likelihood of the finding with the department with the favourable of him or her relief shall not adversely affect with the health of the safety of the public and with the cause of the significant environmental harm with the insignificant damage of the property all hearing with the section conducted in accordance with the section article 10 Illinois Administrative of the Procedure Act over the hearings over the section conducted with the department officer with the located with the Springfield Illinois however the department of Illinois conduct with the hearing with the section at the site of the closure of the Springfield with the production with an injection of this well with identified with the director director's decision being contested with the facilities are available and convenient, but as is determined by the department. All hearings conducted with the section under the public are with the health and complying with American Disability Act 1990. Hearing will be held with the location under according with the hearing officer. The hearing officer hearing the location comply with the geographic requirements imposed by the applicable law with the extent of the visa will promote the convenience of the party conservation of the department to reach over that all the hearings are subject to cancellation without notice that any reschedule of the hearing will shall comply with the subparty with the interest of the person to make contact with the department hearing offer the information hearing with the party with the participant with the members of the public must conduct themselves with the decorum of the hearing. Upon motion of any of the party hearing offer the may order of the hearing with made the telephone conference, video conference, electronic means with the decide with the hearing should be held by the telephone conference, video conference, or other electronic means fact with the hearing officer consider will include with the cost effectiveness, efficiency, facility, accommodation, witness availability, public interest, party preferences within the proceeding, complexity with the continuity. Hearing of the permit shall have the burning and providing with a temporary relief of the cessation will not adversely affect the health or safety of the public, cause of the environmental harm, with the damage of the property. Hearing off the conduct of the hearing with the evidence, the edge of the conclusion of the hearing, rendering finding facts, conclusion law with the disposition of the case, hearing off the issue with the final administrative of the decision, granting with the grief, denying temporary relief of the cessation order, 7 days for the close of the administrative of the record, pursuant to section 10 of the act for the temporary relief shall not exceed 10 days after the cessation order shall be reinstated with the pending of the outcome of the cessation order, pending with the resolution of the violation act as specified with the cessation order. And that was part 24190, temporary relief of the minute hearings. 24195 subpoenas. Any party proceeding with a 240, 131, 31, 132, and 13, 32, 240, 180, 240, 190. Party may apply a subpoena for the witness production of the relevant documents for the applicant for the meeting with the request for the document. Performance hearing offer the subpoena with the subpoena with the request for the specified identified with the witness relevant the documents to be produced. The hearing officer shall with the issue of the subpoenas and set the calendar day with the receipt of the request for the meeting in accordance with the subsection B with above with the delivery with the subpoena with the petition with the self-save with the subpoena issue certified mail return receipt with the request with at least 7 days with the day with the set with the hearing with the witness was thrown with the end with lawful subpoena with the actual knowledge voucher. If a voucher of payment and witness fee with the mileage applicable to the end of the state with the circuit courts of the child has been obtained with the service of the subpoena may be provided with the premium facie by return received with the witness for the authorized agent with the affidavit with the showing with the mailing with the repaid with the address of the witness restricted with the delivery save with the voucher fee and with the mileage enclosed. Any person served with a subpoena with a section may fail with the hearing officer with the serve with the all of the party of the motion with the quashing with the subpoena with the whole and part with all the motion for us followed in a subsection shall be set with a factual and or legal basis for the granting of such a relief. The hearing officer shall issue with the serve with the all the party of the decision granting denying motion to quash 7 calendar days from the receipt of the motion. Alright, that is the general provisions of the Oil and Gas Act. We're going to cut the tape there.